for?
Your Honor, I have a good idea as to how you can resolve this in a way that's fair for both sides. I would suggest that if you're going to admit the free writing prospectus and the redacted loan schedule on the grounds that it is relevant to an element of plaintiff's case, even despite their response in discovery, that you simply allow the defendant to make arguments from any portion of that document that defendants wish to, like in other words, if it's going to be relevant for the plaintiff's case, then it needs to be relevant for the defendant's case. Because what I see on a regular basis is the prospectus and all of those things are totally irrelevant whenever the defendant wants to use them to defeat the plaintiff's case. However, when the plaintiff wants to present its case, certain very highly redacted, certain very small portions of a huge document are relevant to the plaintiff's case, but everything else is irrelevant. It needs to be
the argument that you're not a party to it.
Exactly.
And only the parties to it can complain about it.
And that is a red herring. That is a terrible argument. It's a logical fallacy, and here's why. Because nobody that I know of who's a competent defense counsel has attempted to enforce that contract. We realize we're not a party to it. We're not a third-party beneficiary. However, when that contract, which governs the trust and supposedly sets forth the day-by-day rules of its operation, is completely contrary to or inconsistent with the positions or other evidence presented by the plaintiff, then by all means it defies logic to say the defendant cannot use that document, which is basically the essence of the plaintiff, to impeach the evidence that's being presented. To give you an idea of what I'm talking about, that document provides that all the loans have to be transferred. That means the note and the mortgage need to be transferred to the trust by the closing date or the cutoff date. Anyway, October of 2006, I believe, is that date. And yet here and in so many other cases, they present an assignment of mortgage from 2011 purporting to transfer it to the trust. Let me tell you, Judge, that is an impossibility. It's an impossibility. And in fact, if our system was working correctly, those assignments of mortgage could be taken to the Department of the Treasury, to the IRS, and used in a whistleblower complaint to defeat the tax exemption that these trusts enjoy under Section 88D of the Internal Revenue Code. You see, because the reason that they're tax exempt, Your Honor, is that there are strict requirements imposed by the IRS, which are reflected in these huge, incomprehensible pooling and servicing agreements and prospecti, etc. That's how you get a tax exemption, because theoretically, you put all the loans in the trust.
I'm sorry, I'm not getting anybody.
Thank you. I've been waiting for this moment all my life. The loans have to be transferred to the trust by a certain date. It makes sense. A trust is just that. It's supposed to be a closed shell that goes around. Nothing comes in or goes out, because those would be taxable transactions, you see? So the IRS granted to these financial institutions a new form of tax-exempt entity called a real estate mortgage investment conduit, or REMIC. That's what this is. That's what a trust is. It's synonymous with trust, a REMIC. And the only way that these REMICs can qualify for complete tax exemption is if they abide by the rules so that it's set up a hard shell forms and nothing comes in or out of the trust after the closing date. And what we have is an assignment of mortgage purportedly to the trust from 2011. So if that document is authentic, then by all means, by our law, that document should be able to be presented to the Department of Treasury, and believe me, I have done this. It has to be presented to the Department of Treasury as a part of a whistleblower complaint. You know how they have qui-tams where you can blow the whistle? Well, there's a parallel device now in the Department of the Treasury where there's like an enforcement arm that's supposed to investigate whistleblower complaints, and based on the assignments of mortgage, like in this and every other case, that trust has destroyed itself, it has collapsed upon itself, and defeated its tax exemption. It's impossible.
Why wouldn't it simply be a question of a fight between the trust and the Internal Revenue Service over whether that was a substantial enough violation to hurt their tax exemption? Why would that concern us here in
Well,
court?
it is a matter for the IRS, but what I'm saying is that those assignments of mortgage, like when I try to make the argument that the assignment of mortgage is not authentic or not a real world transaction because it's impossible under the documents which govern the trust, because after the closing date nothing can go in or out, then they say, oh, it's irrelevant. It's irrelevant. You're not a third-party beneficiary under that, pooling and servicing agreement. And that's not the argument.
Case law that says that.
There's one dumb decision from the 3rd District Court of Appeal, and we don't know, it's like a very short decision, and it says, because the borrower is not a third-party beneficiary of the pooling and servicing agreement, they do not have standing to enforce its provisions. I would respectfully suggest also, although I do not know, that the appellant did not make a strong argument, because I know that there are a few people who probably, I don't really respect their professional skills, who have fallen into that trap of thinking that they're gonna, they don't realize, they're not able to draw that distinction for the court. The difference between impeaching the evidence presented by the plaintiff versus really trying to purportedly be a third-party beneficiary, which is obviously not a strong position.
It still may be right for the wrong reason, even if you're correct that they should draw that distinction. Because
we don't know whether that argument was made to the 3rd DCA.
So the question would be whether you can use it to impeach.
Yes. And what I'm suggesting is, given the fact that they objected and said it was irrelevant, if the court chooses to admit what she's asking, then for the purposes of this case, we should be given reciprocity and be able to use it to impeach their other evidence.
By showing that the trust wasn't complied with.
By showing that the assignment of mortgage
is that you impeach them, and you show that by virtue of the dates on the assignment, it's obvious that the trust wasn't complied with under the terms of
Well, that's not exactly what I would argue. I would argue that the assignment of mortgage is a fraud upon the court, that it is not an authentic document, and that...
Why wouldn't it be an authentic document?
Because it doesn't reflect a real-world transfer of any interest whatsoever. It's created just...
The transfer already occurred prior to the assignment of mortgage.
Yes, there's only one...
Why can't an assignment of mortgage be memorialized the earlier transfer?
Well, there is that questionable practice that some firms engage in putting... they put it effective a prior date, but they didn't even do that.
I'm not saying effective a prior date, regardless of whether it says effective a prior date. Why can't it simply memorialize a transaction that occurred earlier?
Because I think it would need to at least express within its term, within its four corners, that that's what it's doing. The way you read it. Yes, sir. Yes, sir.
What I'm trying to point out to you is, why would a court consider it impeachment? Why would a court consider it a fraud when all it is doing, at best, let's say, all it is doing is memorializing an earlier transaction?
Well, I think that's a matter of the court construing the inferences. It sounds to me like, if you analyze it that way, from my perspective, that's just basically bending over to construe all conflicting inferences in the light most favorable to the plaintiff.
But I don't see where's the inference of fraud? That's my question.
Okay.
I mean,
okay. For example, if one reads the assignment of mortgage and takes it at face value, it purports to demonstrate a transfer of the beneficial interest in this note and mortgage on a date to the trust on a date 5 years after the trust closed, which is a legal impossibility. And
why is it a legal impossibility?
Because
That's what I'm trying to figure out why it's impeaching.
And I'll tell you, it's within the document that she's basically trying to present to the court, whereby transfer of mortgage loans into the trust, and there are very specific provisions. In other words, there's only one way, Judge. There's only one way for a loan to become part of this trust, and that's what she's trying to show with that redacted page, is that this loan is part of the trust. The only way that a loan can become part of the trust is as explicitly detailed within the four corners of the pooling and servicing agreement and the prospectus, okay? And that's what a closing date is, that's what a cut-off date is. So according to that contract, which we're not trying to enforce, but we're trying to show that the assignment of mortgage is a fraud, it's impossible. Either you